first will be the appellant, regardless of where they
Right.
sit.
You know, I know the answer to that, but I just have to know where I sit. Whenever you're ready.
Thank you, Your Honor. Good morning, Bart Rockenbach on behalf of the plaintiff and appellant, Emily Renhack. This is a motion for us to add a claim for punitive damages against Walmart and several employees.
You can just keep coming back. If you don't win this one, just go try again.
Yeah, you know, that's the nature of this new interlocutory process where it can,
Increase our work rate at all.
you know, I don't think that was one of the considerations when they
It
passed the
certainly
rule. You know, increase my workload, I know. All of a sudden I start having 10 of these at a time. In any event, the Assistant State Attorney Manning, he testified that the only things he had to decide to charge Emily with a crime was a probable cause affidavit by a deputy and an affidavit from Ashley Greehey from Walmart. And that's it. On video, there was a videotape, a CD with some video on it, of surveillance. Now, the deputy was not an eyewitness. He didn't know anything. He was called in later. And he based his affidavit, his probable cause affidavit, on the affidavit from Ashley Greehey and conversation with her. So let's just go through that affidavit from Ashley Greehey. And I can point out to you, I'm trying to make this as simple as possible because, you know, that stack over there is the appendix. And we're going to try to get that down to a few pieces of paper to make things easier for the court. All right. The affidavit.
I'm just puzzled as to what mutual was the willful and wanton misconduct on the part of Walmart.
Okay.
If I'm not mistaken, it was essentially a confession in the record, a written confession by Ms.
Renhack.
Renhack saying, I know what I did was wrong. Signed this agreement, and I don't know what exactly Walmart was supposed to do that they didn't do, or how they overreached in light of that, as well as some of the other elements and things.
Okay, I can answer that question by going through the affidavit that Mr. Greehey filed for Walmart. Okay, is that all right?
Sure.
Okay.
Ballgame.
Well, yeah, kind of. But I can tell you that the intentional misconduct is facially in this affidavit. All right, Ms. Greehey wrote in the affidavit that all the price overrides were far beyond what would have been allowed by our ad match or BOGO buy one get one competitive price matching policies, were therefore unauthorized and were all performed by the same cashier, Emily Renhack. Now, that is at least a half-truth, if not an outright false statement, because the price policies that Walmart has, there's 3 of them, not just 2. So she's telling the police, or the deputy and the state attorney eventually, that the price overrides were far beyond what would be allowed by ad match or BOGO, but she left out the Sam Walton's, you know, keep the customer happy. Keep the customer happy, discretionary. This is a discretionary with every cashier. So they all have that same ability to do what it takes to keep the cashier happy, not to keep the customer happy, but yeah, cashier happy. Everything's free, everybody, you know, right.
There was only one individual that was receiving the benefit of all these discounts.
There was just one individual. You know, interestingly, that individual was at the register when they came down to get Emily and bring her in for her interview, and they never bothered to find out who that person was. They also had her photo, this customer. They had the customer's photo, and they never bothered to find out who she was. Ms. Greehey assumed, and this is in her testimony, she assumed that Emily knew the person. But Emily said in her interview she didn't know the lady, and that is not in this affidavit. Now, that would be an omission that was intentionally done, which would be another area of misconduct. But let's continue. The next thing she says is, I then began reviewing the electronic record of transactions performed by RenHack and compare them to the recorded video surveillance. What I discovered by observing the recorded video was that all of the unauthorized price overrides were performed for the same unknown customer and resulted in a financial loss for Walmart. This is key. The transactions were carried out by RenHack between the months of July and October 24. She skips down the reason for, on the dates that RenHack performed the unauthorized discounts for the unknown customer, the purchases were often broken up into multiple transactions. The reason for breaking the transactions up appeared to be meant to structure the overrides in such a way as to avoid going over a certain dollar amount, which would therefore necessitate approval by a customer service supervisor. Now that contains several false statements. Ms. Greehey lied to the deputy in this affidavit by saying that first of all, she's saying that they were unauthorized and broken up, they appeared to be meant to structure the overrides to avoid customer service review. What she left out was that the customer service, CSMs, customer service managers, the customer service managers were called over on several occasions and approved every one of the transactions they were asked to approve. There were 5 times that customer service managers approved these transactions. What Walmart, excuse me? Some of the ones were given, yes. Some of the ones that were given were not approved by a customer service manager.
Much like the judge wrote in the order, it seems to me you have a decent argument for negligence, but willful and wanton punitive damages type conduct, I don't see it.
Okay, well, you don't see it yet. I'm going to show it to you. Okay, you don't see.
4 minutes to show.
I'm doing great then. If you have 18 minutes. So this part where she speculates the reason for breaking the transactions up appeared to be meant to structure to avoid CSMs.
Does she use the word appear?
She used the word appeared. Now that's interesting because, and I thought about this morning, it occurred to me, why did she say appeared? Because in her deposition, she testified that Emily admitted it in her interview. Oh, wait a second, what's going on? And going through, and I found it on the appendix page 579, 580. Where Ms. Greehey testified that she wrote this affidavit before she interviewed Emily. Okay, she wrote the affidavit before her investigation had even, she looked at the receipts, wrote out this affidavit that Emily did all these things wrong, and then went ahead and had her interview with Emily, and then she said she signed it before the police, after the police came, but she didn't change the appeared because it was already in there. I guess why change it? But so her entire investigation.
She may not appreciate the significance of that the way that we might.
Yeah, was she? Well, I don't know. She might. Now that's one of those jury questions, right? That's where the jury hears, wait a second, you didn't tell the police about the customer service managers approving these transactions, some of the transactions. All of the transactions were approved. There's two levels. Judge Black, there's 2 levels of approval. One is the register, the machine, the computer system in Walmart approves or disapproves transactions. So every one of the transactions is approved by the computer system. And then when it gets over $50, a CSM has to come over and personally do it. And the CSMs came over and personally did it. So Emily has approvals all over the place. She gets called into the office. The person who is committing, if there's a criminal here, it's this customer who has been doing this. And, Emily is an easy mark, okay? She's probably been identified by this customer as an easy mark. And there's a reason the customer keeps coming back to her. Emily doesn't know the woman, gets no financial motivation from it. She has no financial motivation. So in order for there to be probable cause for a crime, there has to be some criminal intent. Where is it? Where is there any criminal intent in any of this? If Emily doesn't know the customer, she gets nothing out of it.
Apples and oranges, whether it's criminal intent versus the claim for punitive damages. What do those have to do with each other?
Okay, well, I'll take that point head on, is that,
And I'm gonna just tie into that remark, because I think one of the issues underlying this, and it's not just in this case, but in a lot of these cases where someone's not allowed to amend, there's an intentional tort alleged. And then the question becomes, is just the conduct that constitutes the intentional tort enough to allow a claim for punitive damages, or is it, okay, we've got the intentional tort, plus you have to have this additional level of culpability?
right, and the cases are clear that just the level of intentional tort to support a malicious prosecution claim is not enough for punitive damages, okay? But if...
What's your plus here?
The plus, if there's the Kmart case that's cited in our brief where the assistant manager, after the person was arrested for stealing bread, okay, he was a vendor, okay, he was arrested for stealing bread because the inventory didn't match. But after he was arrested, then he was, the assistant manager told the police several months later, oh, by the way, our inventory system is really bad and it doesn't keep track of things very well. Okay, that when he signed out the warrant, he signed out the affidavit to get the man arrested and then told that that was enough for punitive damages. So what do we have here? We have Ashley Greehey. She's lying in this, she lied in the affidavit, okay? She lied in the affidavit. She didn't tell about the CSMs approving things. She says she did that intentionally, all right? Her excuse is that she did it intentionally because she didn't think it was important, but it doesn't matter because she intentionally omitted the CSM approvals. Now, that is an intentional misconduct that warrants punitive damages. The rest of this affidavit is made up of a series of just half-truth, mistruth, and outright lies.
In order for you to be able to allege a claim for punitive damages, which you have to, not only would it have to be intentional, I mean, this is an intentional tort, but like she wanted to get out, she knew Emily hadn't done anything criminal and she wanted to get her arrested, and it, she knew it was likely to happen if she did all these things. I mean, some level of malevolence beyond, like, I just, I didn't think that was important. I didn't include it. Like,
Well,
I
see-
really want bad things to happen to Emily.
Right, but that's not why we're here. We're not here to make factual
No,
determinations.
but you have to allege something from which a jury could reasonably
Right.
conclude that.
So the
So
allegation,
I'm trying to
yeah,
understand what set of facts, viewed in the light most favorable, I think, is where we're at on the case laws.
let's not go there.
Less than clear, because you have cases that say you have to accept it as true and viewed in the light most favorably, don't accept it as true. But, I mean, I'm really trying to understand, like in this scenario, what level of malice, for lack of a better word, would the facts have to allow a jury, would the facts have to allow a jury to conclude there was some level of malice, I guess would be a better way to say it.
Well, the jury would have to be able to conclude that there is some level of malice. The only question at this point is, was there a reasonable basis for the jury to make that conclusion? All right.
And what would be the
The
reasonable?
reasonable basis is, I'm going to tell you just quickly what the jury would hear from us is that Emily had approvals from CSMs to do these transactions. She had that discretionary policy that allowed her to do these transactions. She was brought in for an interview where the affidavit for her arrest was written ahead of time. So it was a preconceived ending. They knew the result before they started. All right. And then the affidavit, the people who are preconceiving this affidavit and deciding how the investigation is going to end, those people left out all of the exculpatory evidence.
So in other words, I think what you're saying is the jury could conclude that Ms. Greehey just had it in for Emily, and she was going to structure this.
Not in for Emily. She had it in for herself. She was protecting her job. See, she has her department, and there's an invoice clerk who's supposed to be reviewing these things every day. And Emily, the first transaction was in July. Ms. Greehey didn't know about it until October. She had been sleeping, off doing, whatever. She's not doing her job, right? Right. So she needed, here's the $1,700 problem that this invoice clerk has alerted the company to. Now Ms. Greehey has to make it happen.
It's like, oh, yeah.
Right. So I'm going to write up this affidavit. Emily, the autistic lady, we're going to have her, she's going to be, okay, fall guy. Got it. All right. It's all written up. And then she didn't give the police officer, their deputy, the receipts. And the receipts would have said approved by having a CSM. Approved, approved, approved. She didn't, it wasn't until 18 months later that Walmart finally gave that information to the state attorney. And that's when the state attorney said, okay, we're going to no process this. This is a problem with all the approvals. So this, the jury listening to this, could a jury, a reasonable jury, hear this and say, okay, yeah, Emily was railroaded, and this confession, Judge Black, you talked about the confession. She testified, Emily testified that Mr. Stapp, who is Miss Greehey's lover, okay, Mr. Stapp told her what to write and said that if you write this, then your prison sentence will come down from 15 years to maybe 5 years. Okay? And here you have this scared autistic lady who's listening to these people, and she's about to be arrested, and she went ahead and wrote. If a jury hears that, could a jury reasonably say, yeah, that confession is worthless. It didn't mean anything. And really the big picture here is that there was a preconceived outcome to this investigation. I'm putting air quotes for the record if there is ever one. Somebody can write this down. But anyway, there's air quotes around the investigation. The investigation was just to quickly do a paper kind of thing, put it together, leave out the stuff that shows that Emily wasn't doing anything. She was misguided for sure. And Emily was misguided. But she thought she had discretion, and she was just told, keep the customer happy. And she told Mr. Stapp, Ms. Greehey, that two of the CSMs, she complained to the CSMs about what was going on and said that she's being bullied by this customer. And she was told by those two CSMs, just keep the customer happy. Don't worry about it, keep the customer happy. She told Stapp and Greehey about that, and they didn't interview those CSMs. They ignored it. She testified she intentionally avoided those CSMs because it wasn't important. The jury can hear that and say, yeah, you're lying, right? The jury could do that. Jury could throw away all of Ms. Greehey's excuses, and that's one of the jury's prerogatives. Throw it all away. Say, you're lying, and what you were really doing was you were avoiding the truth. You didn't want to know what those CSMs had to say. In the answer brief, Walmart points out that those two CSMs, when they had their depositions taken, said, no, I don't recall that ever happening. That was in 2019. Emily was arrested in 2014. So now 5 years later, Emily's she's hoping that these people remember something, and no, they don't remember anything. You know why? Because it's 5 years. Okay, got it. What do we have, like a minute and a half or something?
No, you have 4.
What happened to the clock we used to have?
I don't think we've ever had one. We like to keep you guessing.
Thank you.
Good morning, may it please the court. My name is Jack Ryder here on behalf of Walmart, and Mr. Bolin is here on behalf of the individual employees. And I'll likely use much of the time, and then anything that's left for Mr. Bolin for specific questions.
I'm gonna just cut you off before you even start.
Yes, sir.
Because I think one of the issues underlying this appeal is, okay, they've got this version of events, which, sounds pretty bad. When they give their version, and you all have your version, and why, under the statutory language, why would the trial court have to weigh those? Why is the burden on the plaintiff anything other than come up with a version of facts from which a jury could reasonably award punitive damages, and you go plead them and go forward and we leave it to the jury?
Yes, Your Honor, there are several reasons. Reason number
You get to tell the jury your side.
Sure, of course. Reason number one, Your Honor, starts with the language of the statute as addressed by case law. The statute 768.72 requires there to be a reasonable showing based upon the evidence. Now, there has to be that reasonable showing, and it has to be based on the evidence. Now, evidence.
It's their showing.
Well, yes, Your Honor, but evidence is the totality of the evidence. And this is, Your Honor cited the fact that there's some confusion in the case law in terms of what different district courts have held in terms of the scope of that inquiry. But I'll say this, I think it's critical to start from the premise that there is a fundamental due process right to be free from even the threat of punitive damages. That's why the statute creates the burden. That's why.
The case you filed in Napleton's North Palm Beach says as much.
Yes, it does, Your Honor. So do, and as do a litany of
The
other.
judge is supposed to act as a gatekeeper because it's so egregious to punitive damages that somebody needs to say, wait a minute, is there even enough to allow this exposure?
Exactly.
Well, I don't know, I can read that statute and it looks like a pretty low threshold to me.
Well, here's what I would
You
say.
just read the statute and that's the world we live in, where we're just gonna read the statute, so forget the judicial gloss.
Well, Your Honor, I understand the court's point, and I'll look at it right from the statutory language. And here's what I would say about that. Number one, it's well settled that there has to be a showing based, right? And it has to be.
Plaintiff has to make the showing.
The plaintiff has to make an original proffer, but it has to be based on the evidence in the record. That means it's more than simply a motion
Well,
to dismiss
I
standard.
don't think that means, well, go ahead.
Sure, Your Honor.
So I'm not convinced, let's put it this way, I am not yet convinced that this is a mini trial on punitive damages.
I agree with that, Your Honor.
I think in order to protect that substantive right, you can't just plead it.
And I agree.
You've got to show, hey, I've got something that could get in front of a jury and the jury could reasonably make this determination. And what the other side has to say, well, that's for the jury. And I know you don't agree with that.
No, Your Honor, here's what I agree with. I agree that it is not a mini trial, and I agree that it is not up to the trial court to make decisions regarding credibility. And that is the key distinction. This is not a circumstance where the trial judge, and as Your Honor noted, this was, I think, the third attempt by plaintiff to advance this claim for punitive damages. This was not a circumstance where the trial judge made credibility determinations. He did not say, I believe Ms. Greehey, and I don't believe this person. What the trial judge did, and I believe quite correctly, was he systematically evaluated the totality of the evidence. And he looked at the totality and he examined how certain representations made, for example, by their expert, were simply not consistent with the evidence in the record. So it's not a credibility determination.
Well, it sounds a little bit like a credibility determination.
Your Honor, respectfully, quite the contrary. The judge did not say, I don't believe this expert, or I don't believe
Well, to
this
say it's
witness.
inconsistent with the other evidence, I mean.
No, Your Honor, not the
Okay,
other evidence,
all right.
not the other evidence, the evidence. He didn't say, I'm weighing Mr. Donahue's affidavit against this other evidence. What he said was that the affidavit of Mr. Donahue, which drew legal conclusions and drew statements of intent, was not supported by the actual evidence in the record. So it's not about competing evidence. It's about examining the evidence and drawing conclusions. And I think it's critical, Your Honor, when one looks at first, again, and I believe it is a very high threshold, as Judge Black noted, to even pursue punitive damages. But again, putting aside that point and addressing the comment Your Honor is highlighting, when we look at the totality of the circumstances here, the totality, and we look back not in the hindsight capacity, but if we look at whether or not these individual employees, at the time that they were doing this investigation, acted in a manner that is consistent with gross negligence, egregious misconduct, the type of conduct that rises to the level to allow punitive damages. This isn't about whether or not plaintiff will have her day in court. This is about whether they can pursue this extra measure. And when we look at the facts, we know here that at that time, when this affidavit was created by Ms. Greehey, when the investigation was done by 3 individuals, we had Mr. Stapp in the room, Ms. Greehey in the room, and Ms. Cruz, who there's been no allegation that she had any involvement with anybody in this situation. We have a series of discounts, 48 different transactions over the course of 4 months, being discounted to the same customer with ranges. We put this all on our brief, but we've got discounts where there were discounts where every item, for example, is discounted.
How many weren't approved?
I'm sorry, Your Honor, say,
How many were not approved?
Well, I believe there were 4 or 5 total that were approved and 48 transactions that were
So
suspect.
only 4 or 5 were approved?
Correct.
Out of 48?
That is correct.
And approved by the CMS or?
CSS, a customer service manager, and that was to be.
How about approved just by?
One was by the register.
Okay.
Yeah, yes, there are 4 by CSMs, 1 by the register. And of course, why that is so significant, right? We're looking again at the frame of mind of these individuals. We have invoice reports that are created. They are brought to the asset protection manager. So the invoice report created was brought to Ms. Greehey. Just like Your Honor pointed out, there's no malevolence here. There's nothing to indicate that Ms. Renhack was singled out. Quite the contrary. When the report was first brought to Ms. Greehey and it was shown to her that there were suspicious transactions, it doesn't even identify at first the name of the individual. It just shows that there's suspicious transactions for a certain cashier. That's when the investigation began. They realized that between June and October 2014, we've got dozens of transactions with these inexplicable reductions. On October 4th, the customer, and it was the same customer over and over and over, was supposed to have paid $395, but instead was discounted down to $47. On October 3rd, every item was written down to 88 cents, even though there were a variety of different items. We've got transactions on October 20th, where many items, including food items and other items, were all written down to 39 cents. So what we have is an objective indication of something going on. They watch the video. They see that it's the same individual over and over and over again. One can draw a conclusion that there's a relationship between the individual and the cashier, and that's why she's getting these repeated discounts. And by the way, it is clear from the video that no price match advertisement was shown. Some of the items were Walmart branded, so there was no price match to even provide. The videos are watched, and then there's an investigation. They bring Mr. Stapp and Ms. Cruz from other stores. So again, that eliminates this concept of any sort of malevolence or targeting. The investigation, the interview of Ms. Renhack is performed, and Judge Black, as you pointed out, she confesses, she admits. And what does she admit? She admits, number one, that she's familiar with the policy, the price match policy. So there's no confusion about whether or not she's unaware of what her roles are. And she acknowledges at the end that what she did was wrong. She admits it. Ultimately, it was the law enforcement that drew independent decisions of probable cause, and it was Mr. Manning, the state attorney, who testified, number one, that he believed there was probable cause to pursue the inquiry further, and that he believed he even had enough evidence to obtain a conviction had it gone forward. You know, respectfully, I believe here it is a very high burden to obtain punitive damages, to even seek it. The plaintiff has not met it
So you
here.
think the burden's higher than what the statute sets out?
No, I believe the burden is explicitly set forth in the statute. When I talk about what the case law identifies, Your Honor, I just believe that, and again, I don't know if the court intends to go down that road, but I do believe that the 4th District has correctly identified the fact that it is significant enough that the trial judge should act as a gatekeeper and not simply allow a proffer that's unsupported by evidence to go. Yes, Your Honor.
Because it piques my curiosity. Like, you read that statute, and if you just take the statute and what it says, to me, that doesn't look like a very high burden. And then there's a lot of this language in the case law that we're all familiar with. But if you look at the standard jury instructions, there's nothing in the standard jury instructions like equivalent to manslaughter or any of that. That's not what the jury's instructed. The jury gets verbatim what's in the statute. So why are we arguing? Why is it supportable to argue when you're just trying to plead a claim that you have to show more than what a jury's going to be asked to determine when they read that standard jury instruction?
Here are the reasons why, Your Honor. First of all, I respectfully read the statute a little bit differently than I think you're interpreting it, although I believe that it is quite clear that it does impose what I would suggest to be a higher burden than, for example, surviving a motion to dismiss in terms of stating a claim. We, as Your Honor, as everyone is well aware, you cannot plead a claim for punitive damages in the first instance. There has to be a special showing. that in of itself creates the higher burden. When you look at the statute, it says, in any civil action, no claim for punitive damages shall be permitted unless there is a reasonable showing by evidence in the record or proffered by the claimant, which would provide a reasonable basis for recovery of such damages. That is right there, Your Honor, a higher burden, because it's not about a prima facie, it's about reasonableness. It's not simply that could establish a prima facie ability to pursue a claim. It's not stating a cause of action. It's showing a reasonable basis to even go forward. And that, I believe, is a higher standard. And unless, yes, Your Honor.
Punitive damages claim. I'm looking in the record for something like they jerked her by the neck and they handcuffed her, they jerked her by the neck and swore at her and kicked her out in the street and, you know, wanton, willful, reckless, crazy conduct. Now, here, the objective evidence is that she's stealing from the company. It's objectively investigated. She confesses to it, and she's arrested. I mean, what is Walmart supposed to do? What did they do wrong, and what are they supposed to do? I don't see it.
You are absolutely, I agree completely, Your Honor. And I could not have said it any better than Your Honor just did. And the investigation, you're absolutely right, Your Honor. The record shows that the interview was done respectfully.
Nobody's got it in for. Everybody's using moderate tones. There's no grudges. She'd been working there a while. I would think they're probably disappointed to see this happen.
I agree completely, Your Honor. The last thing I'll say is, of course, there is a second threshold that has to be met to even pursue punitive damages against the employer, Walmart. And I start from the premise of they do not have the conduct here to pursue punitive damages against the individuals. And the next level, again, there's no indication that the entity, Walmart, that these were individuals who are officers or controlling members of the corporation, as case law has identified and articulated that standard to impose. Unless there are any further questions, I'll reserve some time for counsel for the individuals. Thank you, Your Honors.
You have about 7 minutes.
Yeah, may it please the court, Andy Bolin on behalf of the individual defendants, Greehey, Stapp, Cruz, Bennett, and Trisham. I don't want to be repetitive to the court, so I would simply adopt the arguments that have been made by my co-counsel. I'm happy to address any of the questions that the panel may have. I think when we look at the timeline, or we look at the way that this investigation and this ultimate arrest unfolded, we have suspicious activity that was confirmed by employees and taken to what amounts to a supervisor and a customer service manager with the asset protection department with Ms. Greehey. Ms. Greehey then pulls a variety of receipts and creates a spreadsheet that shows the amount that was at issue in each one of these transactions. Then they go to the video evidence and review the video. They then bring in Ms. Renhack for an interview. As has already been pointed out, there's no evidence that during this interview there was anything other than regular conversational tones. The door was not locked during this interview. The evidence is that everybody remained seated during the interview, and that Ms. Renhack was then given the opportunity to write her own statement. This was not something that was given to her and said, please sign this. She is the one who actually filled out the statement that said, I understand this was wrong. The other individuals, Ms. Cruz and Ms. Greehey, who were in the interview, both of them testified that in addition to the statement that Ms. Renhack gave, she also said during the interview that she recognized that these policies, or these write-downs on the costs of these items, were not consistent with Walmart policy. So she acknowledged that she understood the policy and that these were inconsistent with those policies. And she even then went so far as to say that she believed that some of these discounts were unreasonable. So it's not even that these employees came to this conclusion on their own. This was all verified and confirmed by Ms. Renhack during the interview process. They then provided this information to the police officer. And of course, Walmart doesn't dictate, nor do any of the individual employees dictate what she is ultimately charged with. They make the decision, they meaning law enforcement and the state attorney's office, make the decision that this is ultimately amounts to a grand theft. So there is just simply no evidence whatsoever that there was any intentional or willful wanton misconduct. The employees themselves have never testified in this case that they knew that there was something incorrect or unverifiable with what they have provided to law enforcement or the state attorney's office. And when you look at the cases that were cited by the appellant, he mentioned the Kmart case, which is the Sellers case. That employee said that he knew that the inventory was incorrect and that he lied to law enforcement officers. There's no such evidence in this case on behalf of the employees, and for those reasons, we would ask the trial court's decision to be affirmed. Thank you.
How long do I have, Judge Kelly?
You've got 4 minutes, and I'm going to start, because I was looking back through your argument. Are you using a theory of gross negligence or intentional
Intentional misconduct.
misconduct? Okay, I just want to make sure I was clear on
Yes.
that.
Judge Black, you have recounted a series of items showing, in every time that this doesn't show punitive damages. I will tell you that all of the things you have recounted, those 4 things, last time it was objectively investigated, she was committing a crime, no one has it in for her, and she confessed, Emily confessed. Those are all factual determinations. You have just sat as a juror and decided which part of the evidence you're going to believe. Emily says she didn't confess. She said she wrote that down because she was told to in order to get her sentence from 15 years to 5 years. Okay, so she didn't confess.
Under the statute, the trial judge has to weigh one against the other.
No, that's incorrect. The 4th District has, we're going to go through this real quickly. The 4th District in Bistline talked about how we do not just weigh, we don't just take allegations as true and rubber stamp it. Okay, that was an
Because
allegation.
there was case law that said you accept it as true, like you would.
Right, Despain.
Right.
Right. Despain from the 5th, they say, this is what you do. You accept it as true. You look at evidence, okay? The 4th District talked about allegations because that's what happened in that case.
Right.
Then we get to the KISS Group case, and in there, the 4th District has this unfortunately worded statement that 768.72 necessitates the trial court to make factual determinations. Okay, but that can't be because the statute does not authorize a trial judge to make a weighing, I did it in the brief, that Lady Justice, weighing this evidence and that evidence and deciding which to accept. That's not what it is. It's looking at the plaintiff's evidence and saying, okay, the case most most favorable to the plaintiff,
Right.
is that enough for a jury to reasonably conclude there are punitive damages warranted here?
The trial judge is still entitled under the statute to look at what is the evidence in the record, not just what.
Yes, he can look at the evidence, sure, he can look at all the evidence in the record, but he's not allowed to pick and choose which to believe. What he did, if you read that,
He doesn't have the right to make the decision as to whether there's even enough for a jury to consider it or not.
there is, but he can't just say,
The judge doesn't have to ignore the fact that she's written this confession and.
yes, he does. He has to ignore that because she said she did it under duress.
That's what the case says.
What, you're not reading, you're reading, I don't know, shoot the name off to me, we'll talk.
Napleton's-
Napleton's North. Yeah, that,
Napleton's All Auto Park.
yeah, all of those 4th District cases, they do not conclude that the judge is allowed.
Section 768.72 requires the trial judge to act as a gatekeeper, which means the trial judge does simply accept the allegations in the complaint or motion to amend is true.
Yes,
Right on the
yeah, allegations again. You hear the word allegations. You do that. The 4th District has
That's why
been,
you have to have.
you have to have evidence.
Now, the case law.
Yeah, you have to do that. And it is not, excuse me?
Case law is very confusing as to what the trial court's role is.
Right, and I don't, but nobody has certified conflict with each other, all these different cases, because there is no conflict. The 4th District's talking about allegations. You do not take allegations as true. You don't just say, yes, I agree with everything you've told me, but I have to make sure you have evidence to support it. Look at Holmes versus Bridgestone.
Wasn't there case law also to the effect that you have to view that evidence in the light most favorable?
Yes, all of them say that.
Yeah. So
Yes.
I think that's pretty
As
consistent.
Despain, and then in Cook, I did as a supplemental authority, that case criticized the trial judge for making factual determinations. Mr. Ryder says these are not credibility determinations. Certainly they are. A jury listening to this could say, Ashley Greehy's lying. Because and let's look at the big picture, she and Mr. Stapp were having an affair. Mr. Stapp was getting divorced. His house was sold, his house is in foreclosure, it's being sold. He needs a place to live. He moved in with her. This is all part of the record. So they have this relationship going on that nobody knows about. And the jury can hear that and say, wow, she's lying in order to cover herself. And Judge Black, you can't make that factual determination here. You can't say, I believe Ashley Greehy, I don't believe Emily.
We need to wrap up.
Okay, we have the evidence that Walmart participated in this and condoned and ratified is that EEOC thing. The EEOC document where they adopt everything that Ms. Greehy said and did and use that as an example or a reason for why Emily was fired, and it was a good faith basis. Holmes from the 4th DCA accepts that kind of evidence.
Okay, thank you.
Thank you.
Interesting arguments, and I guess we'll probably see that again. If you don't prevail, try again and keep coming back.
All rise. Thank you. Travel safe.
Take care.